We shall commence this module by discussing about WTO. The formation of WTO as an institution to maximize and promote welfare through trade liberalization realized the dream seen 2.5 centuries ago. WTO is a legal body comprising of 148 member countries for multilateral trade agreements on products and services, which includes intellectual property rights, dealing with the trade rules between member countries at an international level. It appreciates immunities and privileges similar to IMF, UNO and World Bank. This organization came into being as a result of negotiations, and all the decisions in WTO is the result of negotiations. The large chunk of discussion is a result of the Uruguay round and the Doha development agenda. After studying this module, you shall be able to be familiar with the Agreement on Investment and Agriculture, understand different modes of trade in services, identify coverage of intellectual property rights, know brief summary of WTO agreements, and assess the impact of WTO agreements on Indian economy. Let us first discuss about WTO agreements. Replacement of its predecessor GATT by a new multilateral trade institution paved the way for the establishment of the World Trade Organization on 15th April 1994, was signed by the participants in the Uruguay round of 1986 to 1993 during the ministerial conferences in Marrakesh. The emergence of WTO is based on several rounds of trade negotiations and different agreements agreed upon by member nations during the decades of multilateral trade negotiations. All the WTO agreements, including the GATTs, TRIPS, TRIMS, AOA, MFA and DSU, are integral parts of the Marrakesh Agreement. Agreements for trade in goods. The agreements in trade in goods are regulated by the following 13 specific agreements as under: General Agreement on Tariff and Trade 1994, Agreement on Agriculture, Agreement on Sanitary and Phytosanitary Measures, Agreement on Textile and Clothing, Agreement on Technical Barriers to Trade, Trade Related Investment Measures, Anti-Dumping Measures, Custom Valuation Methods, Pre-Shipment Inspection, Rules of Origin, Import Licensing, Subsidies and Countervailing Measures, Agreement on Safeguards. Although WTO agreement coverage is comprehensive, but we shall confine our study to select agreements of multilateral trade negotiations like GATTs, TRIPS, TRIMS and AOA. WTO agreements. Trade related intellectual property rights, that is TRIPS. TRIPS deal with intellectual property rights, that is IPRs. It covers all types of IPRs including copyright, trademark, patent, etc. The main features of TRIPS agreement include uniformity in patent and other IPR regulation by all member countries. The distinguishing features of the TRIPS agreement is that it provides for granting protection for intellectual property rights. Especially it gives recognition to the product patent also. The deadline for product patenting for all member countries is 1st January 2005, but for LDCs it is 1st January 2016. Intellectual property rights. Intellectual property rights refers to the rights given to the people over the creation of their minds. They usually gives the creator an exclusive right over the use for a certain period of time. Patents. Patent is one of the most important IPR under which protection is granted for an exclusive right to exploit an invention. The invention must be a product or a process that provides a novelty and must have commercial applications. The owner of a patent is usually granted 20 years of patent protection. Product patent. Article 28 of TRIPS confers on the owner of a product patent an exclusive right to prevent third parties without his consent from the acts of making, using, offering for sale, selling or importing that product. It authorizes the owner of a process patent to prevent third parties without his consent from the acts of using, offering for sale, selling or importing a product obtained directly by that process. Process patent. The TRIPS regulation provides for registration of both the product patent as well as a process patent under the new patent regime. Prior to this, product patent was not recognized and therefore the same product could be registered under different brand names with minor differences in the process of manufacturing the product. Section 5 of Indian Patent Act 1970 did not allow product patent for food, medicines or drug or chemical substances, and only methods or process of manufacture was patentable. However, from 1st January 2005, product patent has been allowed for pharmaceuticals, food items and agrochemicals by deletion of Section 5 of the Patent Act 1970 through the 3rd Patents Amendment Act of 2005. Copyrights. The Berne Convention 1971 deals in detail about the copyrights, and Article 9 to 14 of TRIPS agreement deal with the members' obligation in relation thereto. Copyrights include the right of the author of computer programs and cinematographic works apart from the general work of art and literature. Article 12 provides for protection of copyrights for at least 50 years. Trademarks. Trademark has been defined under Article 15 of TRIPS. It means any sign or any combination of signs capable of distinguishing the goods or services from those of other undertakings. The term of protection is for 7 years and is renewable indefinitely. The owner of a registered trademark has the right to assign his trademark with or without the transfer of his business. Geographical indications. Geographical indications means any indication that explains the goods having origin in country's territory or a region in the territory or say locality in territory given a qualitative reputation or other goods feature is in a sense attributed to its geographical root. This means that the geographical indication has to indicate that a good of a particular origin has a stated quality or reputation or some other characteristics which in a sense attributed to its geographical root. Industrial designs. Designs broadly implies to the characteristics of shape, pattern, configurations or composition of lines or colors which is tested to any commodity by any industrial process or means which is judged by eyes. The provision governing the rights are dealt in Article 25 and 26 of TRIPS agreement. The holder of the industrial design which is protected have the right to forbid third party people from copying it in the sale or import of their articles. The duration of the protection is generally 10 years. Trade secret. Article 39 of TRIPS agreement provides for a protection of undisclosed information of a commercially sensitive nature. Trade secrets with commercial value must be protected against breach of confidence, breach of contract, inducements and other acts contrary to honest commercial practices. Furthermore, reasonable steps must be taken to keep the information secret. Governments must protect against unfair commercial use, test data submitted to obtain marketing approval for new pharmaceutical or agricultural chemicals. Disclosure of information. The WTO disclosure requirement is of particular relevance to patents. Although patent owners have exclusive property rights over their inventions, they cannot withhold technical legislations. Most countries require applicants for patents to disclose such information on the products or processes to be patented, enabling technically qualified persons to understand and use it for further research or for industrial application after the expiry of the term of the patent. Compulsory licensing. Article 31 of TRIPS agreement displays mandatory licensing. It implies a special right or license acknowledged by the government authorities to individuals or companies apart from patent holder to use patent rights, to use, create, sell or import a good under patent without the permit of the patent holder allowed under the WTO. TRIPS agreement provided certain procedures and conditions are satisfied. For instance, the individual or company appealing for a license must have initially tried, not successfully, to get a voluntary license from the right owner on rational terms which are commercial, and required remuneration must be compensated to the right owner. The authorization granted under compulsory licensing must also meet certain requirements. In particular, it cannot be exclusive and it must, as a general rule, be granted predominantly to support the domestic market. Protection of traditional knowledge. Traditional knowledge means a body of knowledge, practice, technology and belief evolved over a period through adoptive processes and handed down through generations. It is done through cultural transmission within a community. It includes knowledge and beliefs associated with a biological resource. TRIPS agreement does not provide any protection for traditional knowledge. Exclusive marketing right. India's Patent Act of 1970 exempted food or medicine or drug from product patenting under Section 5. The concept of EMR was introduced through Patent Amendment Act 1999 by insertion of Section 24A to 24F, under which the right holder would have the exclusive right to market the products in India for a certain period solely on the basis of a patent granted in any other country and without any investigation by way Indian authority into the patentability of such product. Trade-related investment measures, that is TRIMS agreement, is one of the agreements which comes under Annex 1A to the Agreement of Marrakesh, witnessed at the extreme of Uruguay round discussions. This agreement serves measures in investment that are linked to the commerce and violates Article 3 on national treatment or Article 11 that is related to general elimination of restrictions which are quantitative of the GATT. The restrictions on investment measures relate in a broad manner to local content requirements, trade balancing requirements and export restrictions attached to investment decision making. According to Article 5.1 of the Trade Related Investment Measures Agreement, India had taken recognition of 3 TRIMs as inconsistent with the agreement provisions. Local content requirements in the newsprint production, local content need in the rifampicin and penicillin G production, and balancing dividend need in the case of investment in 22 category consumer goods. Such notified TRIMs were due to be eliminated by 31st December 1999. None of these measures is in force at present. Therefore, India does not have any due responsibilities under this agreement as far as notified TRIMs are concerned. The holistic approach adopted in TRIMS agreement has led to the liberalization of global capital flows and led to the massive inward and outward flow of investments across countries, providing new avenues for global investment. Agreement on Agriculture, that is AOA. Let us first understand the salient features under Agreement on Agriculture. There are 3 pillars to Agreement on Agriculture, namely domestic support, export competitiveness and market access. There are other issues of multifunctionalities or non-trade concerns or development issues. Domestic support. Domestic support implies various kinds of direct or indirect supports provided by the government to the agriculture in their home country. This involves subsidies on input in the form of energy, irrigation, fertilizers, seeds or pesticides, or it may involve indirect support in the form of research and development work for agriculture in general. These domestic supports are subject to certain restrictions and commitments for reduction or elimination of these subsidies, and particularly those which are of the nature of trade distortions. These subsidies are exposed to limit called as aggregate measure of support. Amber box. All type of domestically given support allotments recognized for production and commerce distortions, incorporating some exceptions, comes under this category of box. It included in Article 6 of the Agreement on Agriculture as all domestically given aids excluding those which are explained in the blue and green boxes. These have inclusions of allotment to aid prices or subsidies intended for quantities of production. Blue box. These are furnished to farmers usually in developed nations to restrict production as the domestic market is not large and is furnished as a type of allowance to the unemployed. If we speak in a technical manner, this is the amber box with conditions designed to reduce distortions. Any aid that comes under amber box is kept in blue box if the aid needs farmers to restrict their production. These are dealt in paragraph 5 of Article 6 of the Agreement on Agriculture. Green box. The green box is explained in Annex 2 of the Agreement on Agriculture. For qualification, greenback subsidies must not do trade distortions or at the most be the reason behind even a minimum distortion. They have to receive funds from government and not indulge in price support. These are the types of programs which are not focused on products particularly and may have inclusion of direct revenue aids for farmers not linked to the production at current prices or levels. They also have inclusion of environment safeguarding and development programs targeted at particular regions. Subsidies under Green Box are permitted without restrictions and are furnished. They agree to criteria which is policy specific set out in Annex C2. Aggregate measure of support. The trade distorting domestic support is measured in terms of what is called the total aggregate measurement of support, that is total AMS, which is expressed as a percentage of the total value of the agricultural outputs and includes both product specific and non-product specific support. The Agreement on Agriculture stipulates a reduction commitment of total AMS by 20% for developed countries in 6 years, that is from 95 to 2000, and by 1/3% by developing countries in 10 years from 1995 to 2004, taking 1986-88 as the base period. However, domestic support given to the agricultural sector up to 10% of the total value of the agricultural produce in developing countries and 5% in developed countries is allowed. In other words, AMS within this limit is not subject to any reduction commitment. AMS deals only with trade distorting support, that is amber box, and does not apply to green box and blue box subsidies. Development box. It is a proposed addition to the 3 categories of domestic support as already contained in the WTO Agreement on Agriculture and as stated above. Some developing countries have argued for flexibilities that would apply only to developing countries to promote rural development and food security. These would include protection of staple products through exemptions from commitments, higher tariffs and safeguards, in addition to a prohibition of the dumping of farm products by developed countries and the establishment of a food security fund. Similar to Green Box, Development Box would not be subject to reduction commitments. Export subsidies. Export competitiveness implies that no export subsidy should be allowed on farm exports by the government of the exporting countries. Generally, only developed countries, especially EU, provide this type of subsidies for which commitments have been made by them in Doha Declaration for phasing out, but no progress has been made on this account, and this was also one of the measure point of the dispute in Cancun Ministerial. The current negotiations are on the basis of July 2004 framework. The developed countries are asking for a trade-off with more concessions and tariff for more market access in developing countries. General Agreement on Trade in Services, that is GATS. GATS deal with Agreement on Trade in Services, that is services relating to banking, insurance, information, technology, telecom, health, education, etc. There are 12 sectors and 161 subsectors of services covered under GATS. The agreement dealing with services provide 4 different modes of services across the borders from one country to another among member countries under Article 1 of GATS agreement. Mode 1. Cross-border supply of services. Under this mode, the service provider and the service consumer stay in their respective countries and the services move from one country to another country through information technology or through the telecom services, and they are popularly known as e-commerce or business process outsourcing. Mode 2. Consumption abroad. Under this mode, the services are provided in the home country of the service provider and the service consumer has to move from his home country to the country of the service provider, and therefore this is known as consumption abroad. These types of services generally include tourism, health, education, etc. Mode 3. Commercial presence. Under this mode, the service provider moves into the country of the service consumer through commercial presence by opening a branch office or through business collaboration in the form of joint venture abroad or by setting up a subsidiary company. The examples under this category are Citibank operating in India through its various branch offices, or various insurance companies operating in India, or Infosys operating in USA through its branch offices. Mode 4. Movement of natural persons. Under this mode, the service provider is not a company but the individual himself who moves from his home country to the country of the service consumer, and therefore this mode is described as movement of natural persons. This involves issue of visa for temporary stay of the person, and the member countries of WTO are thinking of issuance of GATS visa for specific types of services for which commitments are being made by them for free movement of natural persons on fulfillment of educational and other technical qualifications. Most Favored Nation Treatment, Article 2. With measures under this agreement, each and every member is to accord services and suppliers of service of any other treatment no less favorable than it accords to like services and service suppliers of any other country. There is a provision for exemptions to above provisions, and a member can maintain MFN exemptions normally for 10 years. Transparency, Article 3. GATS provide for publication of all relevant measures and their intimation to the Council for Trade and Services. It also provides that request for specific relevant information from any member shall be promptly responded. However, no member is required to provide confidential information which impede law enforcement or is contrary to the public interest or which prejudice legitimate commercial interest of any enterprise, public or private. Domestic Regulations, Article 6. Article 6 of GATS agreement provide for harmonization of domestic rules of member countries with regard to the following three aspects. First, qualification requirement and procedures. Second, technical standards. And third, licensing requirements. The regulations should have the following objectives. A. Based on the objective and transparent criteria such as competence and the ability to supply the service. B. Not more burdensome than necessary to ensure the quality of the service. And C. In the case of licensing procedures, not in themselves a restriction on the supply of the services. Moving on to discuss the WTO agreements and its impact on Indian economy. The implementation of WTO agreements will have far-reaching effects and consequences not only on India's foreign trade but also on its internal economy. The impact of WTO on India's economy is staged as follows. The progressive impact of WTO on India's economy can be perceived from the following points. Increase in export incomes. Income effects of the implementation of Uruguay Round Package will be an increase in traded merchandise goods as estimated by World Bank, Organization for Economic Cooperation and Development and the WTO. It is expected that India's share in world export would improve gradually over time depending upon the degree of openness and integration of the domestic economy with the global economy. Next, trade in agricultural goods. Reduction of quantitative trade barriers and domestic subsidies in agriculture is likely to raise international prices of agricultural products. India is likely to benefit from this in the form of higher export earnings from agricultural sector. Although it may affect food prices globally, but this will benefit agriculture sector because all major agriculture development programs in India will be exempted from the provision of WTO agreement. Next, multilateral rules and disciplines. The Uruguay Round Agreement has strengthened multilateral rules and disciplines. The most important of these relate to anti-dumping, subsidies and countervailing measures, safeguards and dispute settlements. This is likely to ensure greater security and certainty of the international trading system. Next, growth in the exports of invisibles. Under the provisions of GATS agreement, member nations have liberalized service sector and thus promoting trade in invisibles. India is a hub of effective cost of services, would like to benefit from this agreement. Next, global movement of capital flows. India has increased the upper cap of foreign investment in various sectors and liberalized the foreign investment policy as per the commitments made to WTO. As a result of this, foreign investment and FDIs has increased manifold compared to the pre-reform period. A number of initiatives have been taken to attract FDI in India between 2000 and 2014. According to Department of Industrial Policy and Promotion, the total FDI inflow soared to 24.5% to US $44.9 billion during financial year 2015 as compared to US $36 billion in financial year 2014. Damaging impact of WTO agreements on Indian economy. TRIPS. The agreement on TRIPS as Uruguay Round weights heavily in favor of multinational corporations and developed countries as they hold a very large number of patents. Agreement on TRIPS will work against India in several ways and will lead to monopoly of patent holding MNCs. As a member of WTO, India has to comply with the standards of TRIPS. The negative impact of agreement on TRIPS on Indian economy can be stated as follows. Pharmaceutical sector. Under the Patents Act 1970, only processed patents were granted to chemicals, drugs and medicines. This means an Indian pharmaceutical company only needed to develop and patent a process to produce and sell that drug. This proved beneficial to Indian pharmaceutical companies as they were in a position to sell quality medicine at low prices both in domestic as well as in international markets. However, under the agreement on TRIPS, product patent needs to be granted. This will benefit the MNCs and it is feared that this will increase the prices of medicines heavily, keeping them out of reach of poor. Again, many Indian pharmaceutical companies may be closed down or taken over by large MNCs. Agriculture. The agreement on TRIPS extends to agriculture through the patenting of plant varieties. This may have serious implications for Indian agriculture. Patenting of plant varieties may transfer all gains in the hands of MNCs who will be in a position to develop almost all new varieties with the help of their huge financial resources and expertise. Non-tariff barriers. Several countries have put up trade barriers and non-tariff barriers following the formation of WTO. This has affected the exports from developing countries. The Union Commerce Ministry has identified 13 different non-tariff barriers up to 16 countries against India. For example, multi-fiber agreements put up by USA and European Union is a major barrier for Indian textile exports. Let us now recapitulate or summarize what we have learnt in this module. The provision of different agreements of WTO further extends the trade liberalization regime through trade in goods, services, intellectual property rights and investment. GATT's provisions are complementary to the provisions of TRIPS, TRIMS, AOA and various other agreements of WTO to encourage integration of global economy. Although overall impact of new multilateral regime is yet to be quantified, but its effect on developing country like India is varied.